I've previously marked this, Your Honor, as Defense Exhibit 1. Your Honor, this exhibit is an exhibit of the State Registrar of the State of Texas. It is an official document under seal, domestic document under seal, pursuant to the Family Code 155. A request made of the State Registrar as to the Court of Continuing Jurisdiction is a statutory obligation of this officer. Under the rules of evidence, this document would be admissible as an exception to the hearsay because it's specifically accepted from the hearsay document. This is a record of vital statistics exempted from hearsay under 803(9). Your Honor, it is self-authenticating because under 902, this is a domestic public document under... Yes, sir.
Number 7.
Yes, sir.
Everything you say is true, but what's your point?
Your Honor, the court in Collin County lacked jurisdiction to enter any orders, and there's only one way that a family court can obtain continuing exclusive jurisdiction, and even the rules of venue under the rules of civil procedure do not apply. The only way that a court may obtain continuing exclusive jurisdiction is by valid transfer order. My point is, Your Honor, that the state is going to try to introduce orders purportedly that we violated, and my objection is going to be to each and every one of their admission that this court in Collin County lacked jurisdiction according to the Family Code, according to the State Registrar whose job it is to make such determinations, and that because exclusive continuing jurisdiction was never transferred to Collin County, these orders are void and have no force and effect, and I'll object based on that grounds. And I would like to have, obviously, that addressed before we get in front of the jury and start trying to introduce these orders. I may be able to speed the matter up just a little bit, Your Honor. There was never an order to transfer, and as my statement of my offer of proof, I have that blank order, and I also have the Honorable District Judge who purportedly, I believe that if the state was to represent to the court that an order of transfer was signed, they would represent that it was the Honorable Robert O'Donnell. I have him available for this offer of proof to state that no such document was ever signed, that no order of transfer was ever signed to Collin County. And because of that, that court lacked jurisdiction under the Family Code to enter any order except an order of dismissal.
Call your witness.
I may call my witness?
Yes.
Good morning, Your Honor. I'm ready for him. It's nice to meet you. Your Honor, may I please the court would call Robert O'Donnell to the stand?
All right. If you'd raise your right hand to be sworn, sir, you do solemnly swear or affirm the testimony you're about to give before the court in the trial of this cause to be the truth, the whole truth, and nothing but the truth, so help you God.
I do, sir.
You be seated up here, sir.
Your Honor, may I treat Defense Exhibit 1 to show to the witness?
I'll hand it to you.
Okay. Thank you, Your Honor. Your Honor, would you please state your name for the record?
My name is Bob O'Donnell.
And, sir, how are you presently employed?
I am a retired district judge, and I practice law.
Okay. And, sir, where did you practice law?
Now,
No, where did you preside?
I was the judge of the 301st District Court.
Okay, and was that in Dallas County?
It was.
And were you presiding on the bench on July 28th of 1989?
Yes.
Okay, Your Honor, are you familiar with the provisions of the Family Code calling for continuing exclusive jurisdiction?
Yes.
And, Your Honor, is it your testimony that the only way a court can obtain continuing exclusive jurisdiction is through valid transfer order of the court with continuing exclusive jurisdiction to that court?
If there is a court of continuing jurisdiction, jurisdiction can only be transferred by a transfer order, if that's your question.
Yes, sir. That's my question. Your Honor, are you aware of Defense Exhibit 1 that the State Registrar of the State of Texas indicates in January of 1996 that the court of continuing exclusive jurisdiction is in Dallas County?
Yes.
Your Honor, is that a domestic public record under seal, authenticated with seal embossed by the state registrar?
Yes?
And does that appear to be the original of that document?
Yes?
Your Honor, I'd move for admission of Defense Exhibit 1.
For the purpose of this hearing, I don't
Right, it's
object.
admitted.
Thank you, Your Honor. And is it a certified public record?
Yes?
Would that document, Your Honor, vest the Dallas court, the 255th, with continuing exclusive jurisdiction?
Yes?
Your Honor, I'd move for admission of Defense Exhibit number 32.
Any objection?
Not for the purpose of this hearing, no.
32 submitted.
Judge O'Donnell, is once jurisdiction vested in Dallas County for continuing exclusive jurisdiction, we're not talking about venue, are we, Your Honor?
No, sir.
All district courts in the state of Texas are vested with venue in a matter, and it must be raised and properly objected to and transferred by the parties. Isn't that correct?
I'd accept that.
We're discussing a matter of continuing exclusive jurisdiction, which is provided specifically by statute, and which can only be transferred by valid transfer order of the court which currently possesses continuing exclusive jurisdiction. Is that correct?
Yes, sir.
And again, Your Honor, I'd like to ask you if that document that you signed accomplished that feat.
It did not.
Here, it has nothing to do with any issue that's going to be determined in this case when it comes to a matter of law. So if we'd move on and stay away from matters of the law.
Sir.
Yeah, pretty shocking to me. Let me explain to you the significance of this transfer order. In family law cases, particularly cases involving children, whatever court first acquires jurisdiction retains exclusive continuing jurisdiction. That means that no other court in the state has the authority to make any ruling. The only way the jurisdiction changes is through a valid transfer. And without a valid signed order, you don't have a valid transfer. That means that there never was a transfer and jurisdiction remained in Dallas County. And if you will read, I've got other excerpts of Judge O'Donnell's testimony in the written materials, and you will see that there never was a hearing on the motion to transfer. There was never any ruling on any of the evidence. And the only judge that could have signed the order and could have transferred the case had nothing to do with the case until July 28th. And he was told that he was only signing the motion to withdraw. The evidence is uncontroverted. It is conclusive. This case was never transferred to Collin County. And that is really significant because once it got to Collin County, that's when all the problems started. But to remove any doubt as to the jurisdictional issue, I want to read you 3 letters One was dated September 19th, 1991. This is from TDHS to the court in Collin County, which says, our records indicate that Dallas County has continuing jurisdiction. Since no transfer of jurisdiction has been received, our records will continue to show jurisdiction in this county. The court did nothing. Didn't investigate this issue, didn't look into it at all. Then on November 17th, 1999, TDHS sent an almost identical letter to the court in Collin County. Still, nothing was done. Then Patricia Hope wrote the state in January of 1997, and on February 3rd, 1997, she received a letter that says, pursuant to Section 155, Texas Family Code, you are advised that according to the central record file, the court which last had jurisdiction of the above individual, which is the minor child, was the 255th District Court, Dallas County. So what is particularly disturbing to me is that not once, but twice, the court in Collin County was flat out told it didn't have jurisdiction, and yet it continued to enter orders and eventually terminated Patricia Hope's parental rights. Those two letters from the state, the September 91 and November 93, weren't sent to Patricia Hope or any of her attorneys, so she had no way of knowing about this at the time. Didn't find out about it until February of 97.